Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Our today's topic is regarding medical negligence. All of you are well aware that in the famous case of Lalit Kumari versus Government of UP 2013, the Supreme Court held that FIR some preliminary inquiry should be conducted before registering FIR in medical negligence cases. Because ordinary negligence or a criminal negligence is different from medical negligence, because medical officer or medical professional is a professional, is an expert in the same subject. The others, they may not be aware of the medical negligence unless it is glaring. Suppose if a doctor forgets to remove the scissors from operation from the abdomen, yes, it is a clear case of medical negligence. But if somebody dies during the surgery, after the surgery, post, so you cannot attribute medical negligence on the medical officer unless it is supported by another medical officer's attestation or statement. This is what is stated in a very famous case of Jacob Matthews versus State of Punjab 2005. Another such incident has come to light, and on 7th of this month, just 2 days back, two judges bench, Justice I think Hemant Gupta and A.S. Bopanna, while disposing the case of Dr.Harish KUMAR Khurana versus Joginder Singh in civil appeal number 7380 by 2009. So they have clearly stated that medical negligence cannot be attributed simply because the patient died or simply because the treatment was not successful. There should be evidence on record, that is appropriate medical evidence should be available, or material evidence should be available. Then only you can fix the medical negligence on the part of the doctor. This is what the Supreme Court held. Just it is in consonance with the Jacob Matthews case. That is why I am making this case already. We discussed about Kishan Rao versus Nikhil Hospital, all these things you know. Now we will go to the incident proper. What happened? So the plaintiff's wife, that is Joginder Singh's wife, Jasbir Kaur, she was suffering from kidney problem. So she visited Apollo Hospital on 8/10/96 and it was diagnosed that her right kidney was malfunctioning. So an operation is necessary for her. So thinking over the matter about the expenses, 2 months time has gone. Ultimately, on 7/12/96, she was admitted in the hospital and it was diagnosed that her left kidney is also partially damaged. So Dr. Mazumdar, who has conducted the surgery, he advised her that it is better to repair or to conduct surgery first on the left kidney, so that if it is repaired, the person can live with only one kidney. Yes, there are instances where people are living, even so-called politicians, they are living with only one kidney. This is called hydronephrosis. So instead of conducting surgery on the right side, better to conduct on the left side. Yes, they conducted, and the Dr. Harish Kumar Khurana, he was the anesthetist. Right? So he applied the gas and other things, anesthesia is given. Right? The operation was successful. And actually, since the operation was successful, the husband and even the doctors also wanted to go for the surgery for the right kidney. But Dr. Mazumdar said that the patient is prone to danger if surgery conducted, but husband and others, of course, normally everybody wants to save the life of any medical victim. Therefore, the concurrence or the statement was taken from Joginder Singh and another operation was conducted. But the operation failed, I think, even though she was kept on automatic ventilator. So she died on 23/12/96 in the hospital itself. So Mazumdar clearly stated that the operation may not be successful because the response to the total failure kidney patients is very, very poor for anesthesia. That is what he has stated, but still they have ventured, but it has resulted in her death. And actually, the problem came regarding the payment of the bills. So Apollo Hospital, definitely they will impose a hefty bill for which this man was not agreeable. Ultimately, he is influential, he made it a case. And actually, a criminal case was also registered in crime number 128/97 under section 304 IPC of the concerned police station. Of course, since they could not find out any medical negligence, criminal negligence is not there. This man was compelled to file a consumer case. So he filed a consumer petition before the State Commission, which has agreed with the actually the allegation of the so-called complainant Joginder Singh. The matter went to the NCDRC also. There also they are satisfied only on 2 points. Number one, the anesthesia by Dr. Harish Kumar was not given properly, even though the doctor stated that the patient was not easily accessible or successful for this anesthesia. Kidney failure patients had poor tolerance to anesthesia. So, of course, second point is the consent of the patient was not taken. So, the doctors clearly, the hospital staff clearly proved that consent was taken from the guardian, that is Joginder Singh. And in many cases, yes, definitely, even though the tolerance is less, some people resist, some people have got tolerance, mental, this thing they can tolerate, and the operations are successful on some occasions. So, it is due to the health condition of the patient, she died, but not because of the failure of the surgery. They have produced the evidence before the NCDRC, but they are not satisfied. Of course, when the matter came to the Supreme Court came after perusing the documents, it came to the conclusion that there is no appropriate medical evidence, because as stated in the Jacob Matthew versus State of Punjab case, the support of the medical examiner, particularly civil surgeon from a government hospital, is not there. And of course, kidney failure, it occurs in so many cases. Therefore, the negligence is not glaring. The negligence on the part of the doctors is not glaring. So, therefore, we cannot find it as a res ipsa loquitur. Things speak itself. This you know, and it will take some more time if I want to explain the same. So, therefore, since the first operation was successful, the doctors are also emboldened that she will tolerate, but she could not. Therefore, she died, and it is not due to the fault of the doctors. So, the appeal is allowed, and the Supreme Court stated that NCDRC has not taken into consideration of the medical opinion of any expert, and things may happen like this, instances may happen like this. So, the amount of 70 lakhs compensation need not be given to the so-called plaintiff. This is ultimately the judgment of Supreme Court. Right? Thank you very much.